What's up, everybody? Starting this one out with a bang, as Netwoman has already gifted 20 Lawyer You Know memberships. So that means it's going to be a good one. It's going to be a good live. Our second live for the day. A bunch of people were asking about Karen Reed. So we took kind of a quick look at what happened in her hearing yesterday, where her attorneys basically said the prosecutors are the target of a federal investigation. So I brought my dad on earlier to talk about that. If you guys want to check that out, it's already up on our page. But today we are finishing up our discussion on Chad Daybell's attorney, John Pryor, asking to bounce his motion to withdraw, which the state objected to. There was a hearing yesterday. We're going to listen to a little bit of the discussion between the lawyers, but mostly what the judge has to say about what John Pryor is trying to do here. A lot of you all had some feelings and thoughts about what his ulterior motives might be for this. So we're going to watch and see if it's about the money or if it's not about the money, and if it's about something else. And then we're also going to see something that very rarely happens, where somebody is forced to work for free. And I know nobody feels bad for lawyers, but it is just such an interesting situation that somebody can look and say, this guy's not paying you to continue to work. Guess what? For the next 2 to 4 months, you still got to work for him for free. And also interesting thought that Chad Daybell's like, I don't really think I want this guy working for me for free. If he's pissed off and doesn't want to help me, or just as like, oh, this is my free client, do I really want that guy representing me? And I think it's kind of a good argument. Thank you, Gringa, for the super sticker. So hit that like button if you guys haven't already. Make sure you subscribe, because we are talking about so many cases. Over the last couple of days, I swear we've had to have done more than 5 cases. In the last couple of days, we've done Murdoch, Koberger, Daybell, Karen Reed now, Alec Baldwin short today. Take Care of Maya. I'm probably forgetting something somewhere. Sarah Boone. It is wild how many cases we are following right now. Capacity seems to be at its limit, but we won't stop. We'll keep bringing the content as much as we possibly can. So let's get into this hearing now. Judge Boyce is here on the left. Chad Daybell is on the right with the white shirt and the tie. His lawyer, John Pryor, sitting next to him. The 2 lawyers sitting next to John Pryor, the female attorney, and the attorney with the 3-piece suit are the prosecutors. So John Pryor has kind of given his opening statement, which we already read in his written motion. And now we're going to kind of hear what Judge Boyce thinks for a couple minutes before we go to the state, so we can hear their objection, because we didn't get to read that together like we did John Pryor's motion to withdraw. If you want to hear me go through that in detail, it's on our Chad Daybell playlist on the YouTube channel.
This puts me in the situation where this court, I don't think, is obligated to, appoint an attorney. Mr. Daybell has private counsel, and I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money.
Well, maybe it's not such a big deal that he forces him to stay on for free, because he could care less about the money. And it certainly sounds like he doesn't want to withdraw. It's a very strange situation. And you'll see, he's like, it seems like the court's impossible to appoint help. Well, pretty sure he's going to allow you to get help and keep you on the case.
Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So,
right.
The judge is exactly right about that. That's exactly what the motion says. And not only does it say Pryor wants off the case, it says Daybell wants me off the case. It says Daybell wants me off the case because he doesn't want me to stay on if I'm not going to get paid, which is understandable. But now John Pryor is saying, I want to stay on the case, and Daybell wants me to stay on the case.
And that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand? But when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. the concern is this, is that at least at this perspective, Judge, I'm going to be
weird because it sounds like that's what you asked for. And if you say you don't need to get paid for the case and you can care less about money, then why would the judge not force you to just keep working for free? Right. And Sandy hit the nail on the head. Could the attorney want to work for free for exposure and publicity? Absolutely happens all the time. It literally happens all the time. Maria, a lot of people felt like this was a delay tactic. The judge and the state definitely hint at that when we get to more of their discussions later on in the video. And you guys are probably not wrong, but it didn't work. Raina, thank you for the super sticker. And Jet Stander, thank you.
doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid. And I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end.
When you give the judge an out like that, he's often going to take it. Unique said, Peter, does Chad have a PD? Not right now. How can a private lawyer get forced into representing someone he no longer wants to? It happens all the time. You take the gig, you know what the chances are that this happens. If the client stops paying, he is in prison. So there's obviously a chance he's going to stop paying for a crime like this. He's not going to continue to make money. And judges commonly force lawyers to stay on, especially if they've been representing them for years and they say it's such a difficult case and the trial is right around the corner. They're not just going to let the lawyer bail, screw the client, and delay the case because now any new lawyer that comes on the case is going to have to take years to catch up. Brianna, how come Pryor isn't death penalty qualified? So he talks about that in the hearing, how he could. He has all the prereqs. He just doesn't care to. He just doesn't want to. And again, he's a private lawyer. He's not a public defender. So a criminal defendant can say, I don't care about the death penalty stuff. I want Pryor. I'm going to pay Pryor. It just means he can't get court appointed in a case like this. He probably didn't think this was going to happen, but here we are. Francis, thank you for gifting 5 memberships.
Regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point,
so there's your answer. He just chose not to. And also, Sad Tiger, that's your answer too. Couldn't he have asked the court to appoint him and be paid that way? No, because he's not death penalty qualified. My Nick, they're going to appoint a second chair. It seems like that was kind of the answer at the end, which we'll hear when we get to the end of the video. But I don't know. I'm not positive whether or not it has to be death penalty qualified since he's in fact choosing and paying for, well, not paying anymore, but has a pro bono private attorney. So I don't know what the rules say in Idaho about that.
I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
So that's the basic argument for the defendant. They step away to talk about the penalty phase thing that Pryor says is like trial strategy. He doesn't want to publicly say it in front of the state and all that stuff. So I'm going to jump ahead so we can listen to exactly why the state is objecting to Pryor getting off this case or withdrawing from this case. First, John, I want to answer this. Do we know how much the attorney has been paid so far? No. And to me, it doesn't matter because some people could say, oh, he's made enough money or, oh, he hasn't. Putting hands in other people's pocket is not something I like to do. Here's what I say. If you say you're going to pay me $1,000 an hour and I work for 100 hours and you've paid me $100,000, I shouldn't have to work hour 101 if you're not going to pay me. That's my opinion. And that's exactly how I would treat an employee. I don't expect them to work for free and they don't expect to work for free, no matter how much I've paid them over how many years they've worked for me, right? I mean, I think if you agree to something, you should have to pay it. And if somebody stops paying, you should get off. But I understand you can't screw criminal defendants. And we get in these situations and judges have to make the balancing call after doing their analysis. And here he said no. And judges have told just about every criminal defense lawyer has found themselves in this position at least once. Maria, what do I think the chances of a plea deal are? I think Pryor would take a plea deal. I don't know that the state is offering anything. I think they're very confident, especially after convicting Lori Vallow. I think they're very confident they're going to go get a conviction. So why would they offer? I mean, maybe life, I guess, would be the best thing they would offer. And maybe if they offer that, they would consider it. I don't know. Tingles tie. This seems like a strategic play. Don't really understand the attorney's endgame. Does he want to be compensated like a public defender? Could this be an appeal play? I think it could open up appellate issues if he says, Judge, I couldn't possibly do this on my own, but if you force me on, I'll try. And then it's an ineffective assistance of counsel claim because he even told the judge in open court that he didn't think he was have enough time and capacity to handle this case. I think it's possible. I think really it was probably a delay tactic, if anything, because if this motion to withdraw was granted, it would have caused a pretty extreme delay in this case.
To conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has, in fact, done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But
the point is, he's had this right to 2 death penalty qualified public defenders the whole time, or since he's been indigent, declared indigent, meaning he doesn't have enough money to pay for counsel. And yet it's been a year plus. We've already had these conversations. The time for that was way back when, not now. This is going to cause unreasonable delays. That's the state's main concern here. It's always risky to object to something like this that the criminal defendant wants, but it carried the day at the end of the day.
they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right, are advised, and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating. But in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point.
And that is an issue, right? And that's something we knew she was going to point out, is there's some conflicts in what he wrote and what he said. Salty Beach Girl, do you think this was a ploy to get the death penalty taken off the table? How would this help that? I mean, I guess you could say if he gets withdrawn and there's a new lawyer and there's a long delay, maybe they talk to the victims and they offer life instead of death. I mean, that's your best case scenario, but I don't really think this was ever going to be something that got that result. If I was a prosecutor, it would not result in that. Monique, Peter, does this jeopardize Pryor's personal practice working for free on a high profile case? So working for free ever obviously could jeopardize your practice. Working on one case 24 hours a day, 7 days a week for 4 months would absolutely jeopardize your practice. That would be an impossibility for me. I would never do that. And it's up to him if he wants to work for free on a high profile case. Obviously, if he goes and wins and does a great job, it could be really great afterwards, and then it'd be worth it. How long does it take to get death penalty certified? There are all different requirements that you can do it over time and doing certain things and taking certain courses. I feel like splitting the baby would be to make Pryor stay on, but then if he gets certified within X amount of time, they can back pay him. I love that idea. And that's kind of thinking outside the box like a judge, but Pryor to force somebody to get death penalty certified, maybe you could just say, if he wants to get paid, he has to get death penalty certified. I actually really like this idea. But again, he would probably say, I can't do that at the same time as representing Chad Daybell. But the reason that lawyers are not quote unquote certified is not that they're not qualified or can't do it. It's just that they haven't checked one of the boxes usually in this. Now, Mark Means, who was Lori Vallow's attorney, seems like he actually wasn't qualified because he had never really handled cases like this. Pryor seems like he is qualified. He has handled cases like this. He just chose not to take that step. Thank you, Donna Cole. I saw that you re-upped on. I know you've been a member for a while. Thank you for gifting a membership as well.
The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This
I
doesn't
gotta
appear to
feel
be a
that
true
way
motion
too.
to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there could be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a
Meaning like you're seeing here now, because we know all this stuff and she's saying all this stuff, how much harder it would be for a new lawyer to come in and handle this case because Pryor has done so much, sat in on that first trial, been involved when Lori Vallow was still defending the case, potentially talking to her lawyers. I mean, it's really tough to recreate that and think anybody's going to be as ready for trial or as competent to represent Chad Daybell as John Pryor.
very good idea of what the trial preparation was going to require at that juncture.
It's true.
So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis.
I like how this attorney just addresses the court. Even when she has questions for the defense, she's like, Judge, here are the questions we have, meaning judge, figure that stuff out before you make your decision.
Different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've
Just like I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case. And as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall
There you go.
position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying, I can't be prepared for trial in April, the state's very frustrated that this is clearly just a valid motion to continue with a different title attached to it, because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
I agree. A veiled motion to continue. Tingles. Peter, what would you do if you were the prosecutor on this case? What would your play be? Probably similar to what she just did. I would not want Pryor off the case. And the more we hear about it, the more I think about it. First off, we say these ineffective assistance of counsel and these appellate issues that criminal defendants are going to have, and we want to make sure that we don't create a bunch of them. But like, Very few criminal defendants, especially on capital cases, go to trial, lose, and then win an appeal. And I think there is almost no way that, unless John Pryor just totally barfs all over himself in trial, sorry if that was graphic, there's no way that he's going to be incompetent in this trial. He has done everything. He has been prepared at every hearing. He knows what's going on. He's zealously representing his client. He's trying to create continuances that he thinks are better for his client. He sat through Lori Vallow's trial. He's been at everything from the beginning, basically. He has gotten these cases severed, which is what he's wanted to do. He's been successful in pretrial motions, as much as you can when you have a case like he has. I just don't see him being ineffective to the level that it would create a real reversible error on appeal. So I think the right thing to do in this case, not always, but in this case, was to object to it. Nancy, do you know how much Daybell's house was worth when he turned it over? A lot of questions about this. I don't know if this actually happened, if it was just reported how much it was worth. I don't know anything about that. Sad Tiger, maybe the lawyer is playing the sympathy card. Therefore, the state would offer a plea deal and then he could argue taking death penalty off. Multiple people have said this. So obviously it must be a thing because a lot of you guys have your finger on the pulse and this is what you're thinking. I don't see how this helps garner sympathy or get rid of the death penalty. Hi, it's not real. Does this happen a lot? A lot is probably too strong, but it does happen from time to time. It's not something that happens 1 in a million, but it doesn't happen a lot either. You got to set up, if you're going to criminal defense lawyer, you got to set up the right way to be paid. Hourly, where you're ahead of the client, is probably not a good idea. Flat rate or flat rate plus hourly, things like that. Can they add a new attorney to assist him with the defense second chair? It seems like that was something they discussed. The state says she doesn't think there's something in the rule that allows that. I think that's how it ends, but we'll hear the judge's final comments here. We're actually going to jump to the judge's ruling here now. It's about 10 minutes long of what the judge eventually decides here.
The ABA guidelines, 2 questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell, importantly, does have the right under the 6th Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, The court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more.
And he's not wrong. And that's the biggest issue here. Don, if the client runs out of money, can't the state pay him with public defender money? In this case, no, because he's not death penalty certified. And if it's a capital case, you're that you would have to be death penalty certified to get or qualified to get state funds. Number one. Number two, not all private lawyers are on lists that can be paid by the state. You have to go through certain things to be on those lists. Number three, most private lawyers don't want to accept the state hourly rate. I'm just being frank. It's pennies on the dollar for what most private lawyers charge for these kinds of cases. So it's not just an easy thing to be like, oh, they can't pay anymore. Now the state can just pay us. Moki Yarns podcast. What happens if the lawyer just doesn't show up anymore? He can be sanctioned by the court. He can be held in contempt. He can be thrown in prison. He could lose his bar license. Very unlikely that a judge tells you to stay on the case and then you just stop showing up. Netwoman, a biggin, 50 memberships. That's awesome. Thank you so much, Netwoman.
Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed. And I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client. Although it may be difficult and he apparently will not be able to be compensated, it's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case.
And that is really important. And again, we've learned we build on things, right? And in Sarah Boone's case, the lawyer wanted to get off. Boone wanted him to stay on. He kind of stayed on. When Boone wanted him off and he wanted to get off, at that point, the judge was like, all right, bring on attorney number 7. Here, if Daybell would have wanted Pryor off and Pryor wanted to get off, I think we could have had a different decision here from the judge. But because they both kind of seemingly wanted to stay on, it really does seem like, Sherry M., that this may have been an attempt at a delay. John said, obviously, it's usually human nature that people won't work as hard if people aren't getting paid. And I think Chad Daybell, at least in the back of his mind, knows that that is true. And I think that's a fact. I think it's sad, but I think it's a fact. I mean, it's fair too. You know, like people have families, they work, they put in a lot of time and education and money into getting, becoming a lawyer. And it's like for somebody to force you to work for free. But at the same time, we know when we take these cases that this is a chance of this happening, and we get to set our prices and the way that we're paid in the beginning, right? That's the other thing about a lawyer is most issues between lawyers and clients, if it's about, I paid this lawyer too much, it's very difficult to win on that as a client, because as a lawyer, it's a free enterprise. You can charge what you want. If clients will pay it, there's obviously lines, but it's all baked into you. You kind of understand what you're getting into.
Finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And
that's a no to John Pryor. No, you are not allowed to withdraw.
So under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that, and we'll go through the procedure to get that properly done. So that's.
And Tamara, there's your answer. Why hasn't Pryor found one? If it's agreed upon, he's got to find one that will and can join the case. And right now, Pryor says he can't do that. Azam, Peter, following John's question, will that be grounds for appeal? I'm sure he's going to try, but I really don't see them finding Pryor to be ineffective and some random 2 new lawyers 3.5 years into the case being more effective. I don't see that happening. Sad Tiger, Netwoman is the membership fairy. Thank you. That and so much more. Tingles, if this is a stall tactic, to what end? I don't get how it helps him. I really don't get how it helps him at this point. Don, why not find an attorney, Roni, who could do the case pro bono, bring them up to speed, then Pryor can go back to his firm and help out. There's just not enough time for that. Pryor's going to have to be the lead attorney. There's really no way around that. No ifs, ands, or buts about that, as they say.
It's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied, and Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today, and I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions?
So that's it for today and for this hearing. John Pryor, not allowed to withdraw, forced to work for free, but can get a capital appointment. It's funny, you can get like a lawyer to assist him. That lawyer is going to be making money. John Pryor is not. But that does seem like the best way to somewhat split the baby and still make sure Chad Daybell gets effective assistance of counsel in trial. All right, we're going to end with this. Rachel said, Peter, what's happening with Alec Baldwin? He should be held accountable for pulling the trigger. Ended up killing Helena, prime of her life, wife, and mother. I am doing a short that we're posting on Instagram probably any minute now, but I also just got sent by Jeannie on Instagram the grand jury indictment in New Mexico. Count 1, involuntary manslaughter, negligent use of a firearm. on or about October 21st, 2021 in Santa Fe County at Bonanza Creek Ranch, located at the address. The above named defendant did cause the death of Helena Hutchins in the commissions of negligent use of a firearm and unlawful act, which did not amount to a felony, a fourth degree felony, Okay. Said count one. And then this also says count one, involuntary manslaughter without due caution or circumspection. Okay. So he has been indicted. I'm sure we will be following this even more. Add this case to the list. It's already been on our list. Welcome to Sue and any other new members that have come along the way. We're pumped. You're here with us now. Next week's going to have to be our members only live, unless I do it from California. I'm going on vacation next week to LA to hang with some friends. That should be fun. Whit and I are doing that. Maybe we'll do a members only live from LA. Who the heck knows? But I appreciate you guys all joining. Thank you, Azam, for the super sticker on the way out. Don't forget to hit that like button. It helps a ton. Subscribe if you guys haven't subscribed yet. Azam, congratulations, 10 years as a teacher. And to all of you that join us, I appreciate you. Pumped you're here. Appreciate the questions and the comments. It makes the content what it is. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.